Well, good morning. Very warm welcome on this very fresh Melbourne morning. And I categorise you all as early morning people. I'm not, but anyway, I'm here. And it's not under duress. It's a great pleasure for me to have been asked to chair the session. It's a panel discussion. It's a little different from the way in which we normally present our breakfast presentations. But by way of introduction, Peter Pascoe is my name. I'm obviously on Michael's list, as are our two panellists. And I'll give a brief introduction in respect of each of them before we then head in the direction of the way in which we intend to proceed today. So on my left, Simon Pitt. Simon came to the bar in 2003, and he's a very experienced member of Michael's list, practicing in the area of commercial litigation and succession law. And if you have a look down Simon's profile on the either the list or on the bar website, you'll see a long list of cases in which he's appeared. Obviously not all of them can be successful, that's the nature of the job, but if you look at it carefully you'll see a very high success rate. Simon is also an active presenter in the area of compulsory professional development and seminars, and this particular panel discussion this morning emanates out of his paper delivered to the Equity St Ninian Stephen lecture series that was conducted recently. Some of you may have been in attendance. If you weren't, well, you'll be able to pick up obviously the threads of everything from the discussion this morning. That is, if you didn't have time to read the paper that was distributed a little late yesterday afternoon. But that's the genesis of the discussion, and that's the background. And there's a link in the sense that Simon is resident at Ninian Stephen Chambers, that illustrious group of barristers there at 140 William Street, and he was a very fine pick to deliver the St Ninian Stephen lecture series for 2017. On my right is obviously another Greens List member, Justin Rizzi. Justin's been at the bar since 2015, so a much more recent entrant to our field. Prior to that, he had a lengthy and successful history as a solicitor, practicing mainly in succession law, and more latterly with Macpherson and Kelly. In his practice as a solicitor, I have to be briefed from or by him from time to time, including in a couple of matters where there were big estates, and one occasion in particular I recall I was junior to Her Honour Justice Macmillan, and the estate was much more than that I could ever think that I could ever lay my hands on in a lifetime. And we only made a very proportionate dent in it in terms of legal costs, and it was successfully concluded at the second mediation. So Justin has come to the bar and had read with Rick Wells, a fine succession law barrister whom many of you will know, and has then embarked on his own career, which has included one of the cases that we'll discuss this morning, Rizzi Sanders. And really these two gentlemen are just a smallish part of a very fine complement of succession law barristers that are on Michael's list, and as well as some of the elder statesmen, as Justin was referring to me this morning. We have a fine array of talent, and some of whom are here in the audience, and I'm not too sure what they expect to get out of it other than to maybe make some contributions. But I formally welcome Eleanor Coates and Terry Constantino, and a new entrant, Regan Morrison, who has recently come to the bar, having been Her Honour Justice Macmillan's one of her associates for the lengthy period, I think, of 3 years. Regan has probably sat through some of the trials that we're going to hear about in terms of some comments coming from the panel in this area of informal wills. All right, enough by way of introduction. Let me start this particular session in the following manner. For those of you who've had a chance even just to glance at the paper, you'll see that there are 8 cases that have been discussed in some detail and discussed in a very helpful way, in that Simon has started off with a statement of principle that he has deduced from each of the cases, which is a very helpful summary. And when we look at them, of the 8, the first, Fast and Rockman, was decided by Justice Habersberger, and the remaining 7 have been decided by Justice Macmillan. Now, of the 8, we have 1 thumbs up and 7 thumbs down. In other words, the Rockman case, there was a successful application for an informal will. In the remaining 7, there has been unsuccessful applications. So the thought that occurred to me, based on a comment that Justin and I were discussing yesterday in the corridors outside the TFM list cases, the words informal will would strike terror into the heart of most legal practitioners in the succession law area, given that strike rate or high level of unsuccessful applications. I know when I was looking at it and thinking about how I might lead in the discussion, it caused a slight palpitation in my heart, just to think of the number of practitioners and the number of clients that had not been able to get over the barriers in this area of the law. But as Simon made very clear in his paper, it's not all bad news. And so I'd just like Simon to be able to satisfy ourselves that this is not an entirely high level of failure jurisdiction.
Indeed. Well, Peter, first of all, thank you very much for that kind and overly generous introduction. Just picking up on what Peter says, it is indeed the case that 7 out of the 8 reported cases that are covered in the paper were examples of unsuccessful applications for admission of an informal document to probate. But that's not necessarily indicative of the number of wills or informal documents that go through the Office of Probates. In the 2015 to 2016 financial year, I believe the numbers are that there were 21,455 applications for probate. About 418 of those were pure informal will applications, meaning they were applications for letters of administration with an informal document annexed. And many of those were dealt with by the Registrar of Probates or by the court on the papers, i.e. without the need for a contested hearing. Some of the circumstances of those informal documents being admitted to probate are, for instance, if a person has committed suicide and they've left a contemporaneous note as to how they want their estate to be distributed, that document is obviously intended to have dispositive effect, and it satisfies the 3 tests, or the 3 limbs of the tests as set out in Fast and Rockman. Then the registrar or the court may well make those orders and admit that informal document to probate. Now, that is an element of this practice area that we don't see as practitioners necessarily, because it doesn't come out in the reported cases. But it's fair to say that those applications are usually successful because of a large amount of work from barristers and solicitors to collect any relevant information as to that informal document, present it to the court, answer any questions that the Office of Probates or the court may have. And so it's not all bad news. The words informal will ought not to strike terror into the hearts of us as practitioners, because there are a lot of examples of successful applications. It's just that we don't necessarily get to see them. So what you've got with the 8 examples in the paper really is literally the tip of the iceberg, and there are a substantial number of successful examples. So that answers that question.
Yes, that provides a bit of balance into the overall view of the field that otherwise you mightn't get if you just focus heavily on the 8 cases or 7 of the 8 cases. So it's a much broader success rate. And Justin, prior to coming to the bar, you were an accredited wills and estate specialist. You would have dealt with some applications before the registrar, and were they as successful as perhaps we're hoping?
I still am actually accredited, Peter. They let me keep it at the bar. You do see if they can be agreed by the parties broadly, but generally where somebody's taking a benefit out of the informal will and the formal will's fairly different, then you often find that the people propounding the informal will are put to proof, because where there's significant change in disposition and therefore a lot of money involved or assets, then the usual course is to put them to proof. But in simple cases of a straightforward revocation or a very clear example of an informal will that might just have some irregularity that doesn't conform with Section 7, they do often get put through. One of the issues that I found is if there's minors or people under a disability affected, and the registrar can't exercise those powers, so they have to go through to Her Honour to deal with. But generally, given the numbers that Simon mentioned, 418 applications, there must be quite a large number either being dealt with by the registrar himself or Her Honour on the papers and in chambers.
Yes, that's the feature when you're talking about, in effect, administrative dealing with these matters. We shouldn't forget the role that Her Honour plays in respect of disposing with matters on the papers. You will have observed that perhaps the probate list on a Friday has just declined to manageable proportions in terms of just the number of people that are attending. So my perhaps uneducated guess is that the level of matters that are being able to be dealt with, including informal wills, obviously, by Her Honour on the papers has increased, and the balance seems to be quite good. And that's a testament to her industry and the assistance provided by her associates, of which I think there are 3 at the moment, aren't there, Regan? Yes, they're a very hard-working group. But just picking up on Justin's point before, his role as a solicitor, a couple of the solicitors haven't fared well in 2 of the 7 cases that are reviewed in Simon's paper, and it's somewhat of a sobering read, I find, to read about our brethren, and to find that some of them are not travelling so well in terms of the way in which their conduct has then been reviewed by Her Honour. And Simon's paper has certainly got some well, not so much tips for young players, but good conduct guides for practitioners that might assist, a checklist of things you might really put your mind to before you embark on this particular process that may cause you to be before Her Honour, either trying to get something through on the papers or in a matter that is heard in open court. Would you just care to comment on the, not so much the derelictions, but some of the pitfalls that some of our colleagues have found in their practice when it's been reviewed by Justice McMillan?
Yes, good point, Peter. Thanks for that. Look, one of the things that struck me when I read through the cases that are mentioned in the paper is that and Her Honour is often critical, not often, but sometimes critical of the way in which the evidence is presented to the court. One reads the cases and gets the impression that there is often a few loose ends which haven't been tied off. There are a number of questions which are raised by Her Honour to which there appears to be no answer on the affidavit material. And one wonders if indeed the applications that were unsuccessful may have been successful if all of those questions had have been answered and if all of the relevant evidence had have been marshalled or corralled before the application was presented to the court. If one looks at Section 9, subsection 3 of the Wills Act, it's clear that the inquiries that the court makes on these sorts of applications are extremely broad. Section 9, subsection 3 states that in making a decision under subsection 1 or 2, which is the informal will provisions, the court may have regard to any evidence relating to the manner in which the document was executed and any evidence of the testamentary intentions of the testator, including evidence of statements made by the testator. So really, our task as practitioners, should we choose to accept it, is to go on a fact-finding mission. If we're presented with an informal document, we need to ask a wide series of questions. We need to cast the net far and wide. Now, that comment is made obviously with an appreciation that sometimes that's just not practicable. These lines of inquiry take time and cost money. And solicitors or barristers, we may simply just not be in funds to be able to undertake that level of inquiry. But the paper sets out at paragraph 18 and again at paragraph 102 at the end a number of questions that are sort of like a checklist. Those questions and those points have been distilled from the cases, and I've carefully tried to collect a number of inquiries that might be made before an application is made. So, for instance, if one looks at paragraph 18, A, you can see what was the cause of death. Was it sudden and unforeseen? Or was it planned, i.e. suicide? Now, if somebody's committed suicide and they have a relatively contemporaneous suicide note, which has or purports to have dispositive effect, then you can assume perhaps that the person intended that document to have dispositive effect and perhaps intended that document to constitute his or her will, notwithstanding the fact that it wasn't perhaps signed properly or witnessed by two people or didn't cover or satisfy the sections of the requirements of Section 7. What was the state of the deceased knowledge of the requirement for formalities of the will? That's something which is picked up in some of the cases, i.e. if a person has a history of making formal wills, but the informal document is no more than a list of instructions or back of the envelope sketch of how that person wants their estate to be distributed, well, it's going to be a mountain to climb to have that document admitted to probate, because it's evident from the deceased's prior conduct that they are aware of the need to make a formal will. So that might be a foothold for the court to use in rejecting or dismissing the application. how did the deceased treat the document? Was it just simply in the top drawer in the kitchen, or was it in the safe with a number of other important documents? That might lend some weight to the suggestion that the deceased intended that document to be treated as being solemn or formal or final. All these sorts of things, I'm not going to go through them further, but there are a number of inquiries that could be made at that kind of due diligence or evidence gathering stage of putting an application together. And if those matters are addressed, and if those boxes are ticked, if evidence is given as to those matters on an application for admission to probate of an informal document, then there's a higher chance, I would respectfully suggest, that the court might accede to the application. But certainly it's not possible to foresee what issues a court might raise at the hearing of an application. But indeed, when you read some of the decided cases, it's pretty evident that there were some omissions in the way the evidence was presented. There, but for the grace of God, go all of us, and it's very, very hard to crystal ball gaze and actually work out what inquiries a court might make. So hopefully those two paragraphs that I pointed to in the paper just might lead you or assist you in the information gathering exercise.
Thank you, Simon. Just segueing from that, the last of the cases that are analysed in Simon's paper is the case of Ri Tang, and that's a case of a Chinese national, and it was an unsuccessful application. It's a very interesting case to read. Cases concerning Chinese nationals are obviously not everyday cases, but in that particular case, one of the factors that caused Her Honour to find against the application was the lack of expert evidence adduced by the applicant as to the successions law of the People's Republic of China. And I'm able to roll that phrase off my tongue reasonably succinctly because I had the good fortune to have Her Honour approve of an application that I, on behalf of my instructor and client, put before her that was dealt with on the papers. We were dealing with a Chinese national, and of course there has been a great volume of migration from China in the last decade or thereabouts. But equally, I think many of us are all too familiar with the fact that the money has been made in China, and on a great many occasions there is a need to return to China to continue that money-making activity. So that even although there might be Australian assets, as there were in Ri Tang, some money's in a Westpac bank account, or in my particular case there was a sizable property in Melbourne, as well as properties and other property in China. And these particular cases really test the limits in terms of domicile and applicable law, and all of those steps need to be gone through. So when you have a look at the summary of Ri Tang, you'll see that there are references to possibly proceeding under Section 9 or having regard to Section 17 of the Wills Act, which is where extracts are picked up relating to applicable law when you've got these overseas elements. And that particular case also raised the issue of that esoteric little area of the law of succession, donatio morta, or gifts in contemplation of death. Not being a classic scholar, unlike my esteemed colleagues. So that's a good one to pick up on what you really need to do by way of going the hard yards to get the case to the level that's going to be required to satisfy the proofs, be they of the registrar or Justice Macmillan. What I thought I might do at this stage is just to move from those general matters and of relevance in particular to solicitors and how they go about their practice in this sort of area, just to the particular requirements of Section 9. Simon's adverted to them, and I thought it might be relevant just to pick up a little bit of the background there. And the easy one is that there must be a document. Now, that's fine. We tend to just tick that and move on and think, well, the hurdles are going to come later in the requirements. But sometimes, of course, you do have not so much a problem, but an area that's a little different, one from the other at that particular stage of any application under Section 9. And Rizzi is one of the cases that Simon's analysed that does bring that wider definition of document into play. I suppose I posed the question to Simon, why wasn't the video sufficient to get the applicant in that case over the line?
It's Justin's turn, wasn't it?
No, I'm just going to use this one. I'm going to segue out of Rizzi into Justin in a moment.
Well, Rizzi involved, that was the case where there was an elderly lady and she had received some pretty aggressive treatment following a diagnosis with cancer and before her death, which had affected her motor skills. And there was a video which was made from her hospital bed whereby she read out basically an informal document, and to cut to the chase, basically the informal document, such as it was, because the definition of document includes videos, it had a substantial effect on her previous testamentary instrument. So there was almost immediately alarm bells sounding, because where an informal document purports to change radically the distribution of a person's assets vis-a-vis their previous will or on an intestacy scenario, that will then put the court on a train of inquiry, and really it heightens the suspicion of the court, or excites the suspicion of the court. Now, even though in that case there was evidence of mental competency by an expert, the medical evidence was quite thin, and Her Honour really couldn't be satisfied that the informal document was not obtained by some kind of undue influence. There was no evidence about who had actually written the text that was read out, and indeed, even though the deceased had lost motor skills, there was no indication of acceptance of that document by the deceased making her mark or what have you. So in those circumstances, the court just simply could not be satisfied that the informal document satisfied the three tests, the three elements of that three-stage test. There were so many factors in that case that just loose ends that weren't tied off. There were too many factors that raised the suspicions of the court, and many examples in that case of questions that perhaps remained unanswered. So the court just simply couldn't be satisfied on the relevant standard of proof, remembering that it is Brigginshaw. So the court needs very, very clear and cogent evidence to admit the document to probate.
Thank you, Simon. We'll return to this matter of Brigginshaw shortly, but what I'd just like to ask Justin, of course, it's not only videos that will fit within the definition of a document, but also computer material. And that is probably an area that's going to occupy succession lawyers more and more in the future, not even in this particular area, but in the whole area of digital assets and the like. I know it's starting to be an aspect of certain administrations. Has anyone, for example, come across a case where the will, either a will per se or an informal document, has actually been on a computer disk? Yes. And how was that able to be dealt with? Was it signed or unsigned, or?
It was just a document on the computer. He printed copies and left it amongst his documents, but in the end decided that there weren't sufficient formalities to even attempt it.
Okay, yes, very good. I hope everyone heard that. It was just a document on the computer, but it hadn't been signed, and there was no other evidence around that indicated that it really was intended to be his last will, or it was a he. But in casting my mind around to the subject matter of this panel discussion, I did come across a recent decision in the Supreme Court of South Australia, re Michael, a 2016 decision there of the South Australian Supreme Court, and there was a document, as it is for law, being an informal will on a hard disk, and it had a digital signature of the testator. So you've got documents satisfied, you've got a digital signature, but of course it wasn't witnessed. There were no witnesses, and that particular application was successful. And the only thing that seemed to trouble the judge, who sailed fairly swiftly through the whole application, was when I make my order, what is it that I actually grant probate in respect of? And because you've got the informal document actually being on the disk, being digitally signed, but the probate was granted of the copy, the paper copy that was the product of that particular computer document. I turned my mind to, well, what if the video in Rizzi or indeed in another case was the form in which the document was there? Well, I presume it'd be a transcript of the video that, if you were successful, would be the document in respect of which probate was granted. The second matter that I just want to look at in terms of documents and how they're dealt with insofar as signatures is concerned arises out of Rizzi, and Justin was counsel for the applicants in that case, and it caught my eye for a number of reasons. One, I thought that it might have been one of the cases that might have been able to have been successfully advanced, but that wasn't to be the case. Before I ask Justin to comment on the question that I'm going to put to him, Just let me draw briefly from the facts of the case, because it's a rather interesting little fact situation, and it's in Her Honour's judgment commencing at paragraph 53. So it starts by saying that the informal document was witnessed by Mr Abrian and Mrs O'Reilly, who both filed affidavits of due execution setting out the circumstances. And when you read that, you think, oh, okay, now I wonder why this is a problem. We've got two witnesses, and there's affidavits of due execution. So Mr Abriam deposed that the deceased was a customer of his jewellery shop, and this is in the shopping centre at Bay Street, Brighton, and she had been a customer for more than 13 years, and he recalled the deceased coming into the shop and asking her to asking him to witness her will, and he agreed to do so. She produced the informal document. He couldn't recall the date it was signed by him or whether the deceased signed in his presence, but then went on to give certain evidence as to the deceased acknowledging and approving the will in his presence. The other witness was Mrs O'Reilly, and she deposed that the deceased was a customer of her news agency, which is just a little way down the road in Bay Street, Brighton, from Mr Abriam's jeweller's shop. Pardon me, and she'd been a customer there for more than 15 years. She came into the news agency about 3 times a week, sometimes just to chat. And Mrs O'Reilly recalled the deceased coming in and asking her to be a witness to a will, and she said something like, "Old bag, I need you to sign something for me." This is a bit reminiscent of some of Lord Denning's. It was a village in beautiful Somerset on Saturday afternoon, and the locals were playing cricket on the village green. So after that informal request, Mrs O'Reilly asked the deceased what the document was, and the deceased said something like, "It's my will," and showed it. Mrs O'Reilly was a keen and prudent woman, so she said to the deceased, "Write out your signature on another document so I can compare your signatures, the one on, as you're now putting it before me, and the one on this document you're asking me to witness." So what we're seeing is here's a deceased who is mindful of the need to have 2 witnesses, and she's gone to one and they've signed. She's then gone to another and they've signed. What are you thinking? How was that informal? Over to you, Justin.
Now's an appropriate time to turn the camera off, please. It's a good question. I think my submission was that it's only at the very lowest limits of informality under Section 7. It really was. And I should acknowledge my learned instructing solicitor in that matter is sitting over there. So we're still coming to grips with the judgment. It was the lower end, and when we saw it, and just to put this in context, the beneficiaries that took under an intestacy, because it was always going to be an intestacy because the deceased had a history of destroying her old wills, so she'd regularly make wills, go and collect the old will when she'd updated the new one, and would take it away to destroy it, or destroy it in the presence of the solicitor or the solicitor's secretary. So there was pretty solid evidence that if this will didn't get up, there'd be an intestacy. So the beneficiaries that took under an intestacy were a domestic partner and the children of the deceased, and the counsel for the children of the deceased, who was our learned colleague Stuart McNabb, and as I think I commented about this yesterday, if there's anything that's not to be known about this area of law, like Stuart is a doyen, as we all know, he took the view on the evidence that it wasn't worth opposing, essentially. He thought it was a pretty solid case, like I did, for an informal will. As it turns out, it wasn't, but that sort of puts it in context that even the children didn't think there was much to it. We thought this was more of your vanilla type, pretty standard informal will applications. The difficulties for Her Honour were come out in the judgment towards the end, as you read it, you think it's all going to be successful, and then it's sort of like a great novel. It turns right at the end. But essentially, she had a history of making wills with solicitors, and this is one of the points Simon's teased out in his comments, which are apt. You need to be able to explain, if somebody goes to solicitors regularly to make a will, why they've gone off on a frolic of their own almost to make their own will. And that creates in and of itself suspicious circumstances, I guess you could say, for want of a better description. That was one of the issues. The other issue was, I think Your Honour said that there was no direct evidence that she'd approved the will in the presence of the witnesses, but which I thought was a bit tough on the evidence, because she had clearly brought a document to those people and said, this is my will and I want you to witness it. She had great storage of the will. She'd stored it. Well, this was an issue. It was a positive and a negative point. She had previously stored her wills when she used solicitors in deed safes with her solicitor. When she took it upon herself to start making her own wills, she kept the original will at her home in sort of a secret location in the bottom of her cupboard, but it was stored with her powers of attorney and her title deeds. So she had her own deed safe. She was certainly deed safe, I say. She had her own sort of special place in her home where she really treated the document with the respect it deserved. But yeah, there was an issue there that she had always stored them as solicitors and then she didn't. And I can't remember the other. Oh, the other issue that was raised towards the end was Her Honour wasn't satisfied as to her testamentary capacity, and she was an elderly person. Although I didn't, because there wasn't any contradictory evidence, that was probably another factor that caused some issues, because none of this evidence was properly tested. The testamentary capacity of the deceased wasn't brought into question, but Her Honour wasn't satisfied. I think it was more obiter than actual reasons. Her Honour wasn't satisfied that the deceased had the requisite capacity at the time of making the will. So, yeah, a bit of an anomalous one, I'd say. If faced with that same fact scenario again, certainly you'd apply to propound it, and maybe the result would be different, as if perhaps a more fulsome trial had been conducted and if everything had been properly tested, and perhaps there was other evidence that could have been brought. It's hard to say. I'm a bit too close to it to comment critically on it, but yeah, there certainly was a lot of evidence put forward to answer most of those questions. So I'm not sure what you put it down to, Peter. Just one of those ones that one of the reasons why, you know, we all advise our clients, and I'm sure you do too, that there is always uncertainty when you go to court. Even the strongest cases have a chance of failure, and even the worst cases have a chance of success. So always better to deal with it yourself than try your luck.
If I could just add something to that, I think that one of the reasons that Her Honour was not satisfied as to testamentary capacity was that the affidavit of the treating doctor, I think, was in a pro forma type format. So this was an issue which came up in the case of Reed Kelsall as well. The expert evidence, if it is to be adduced and if it is to be effective, needs to be tailored to the circumstances of the particular person and the particular deceased. I think normally you see an affidavit from a medical practitioner which just steps through the would have had a sound and disposing mind, would have understood the nature and extent of their estate, would have understood people who might have had a claim, etc., etc. And it just kind of almost cuts and pastes the relevant test out of the cases and puts it into an affidavit form. Now, I would suggest that a treating doctor, if you're going to go to the trouble of getting expert evidence as to capacity, treating doctor should probably go further. In some cases they can't because they haven't seen and interviewed the deceased, but if it is just a pro forma type affidavit, just a 2-pager like that, then you need to brace yourself, because it might not be enough to get the to hit that testamentary capacity ball back over the net.
And this is a good segue into this that I wanted to mention to practitioners, and it comes back to this issue about cost and time as well. Like any witness who puts in an affidavit, if time and cost permits, you should sit down and proof the doctor, like you would any sort of person making an affidavit, and go through the proper tests of capacity and produce a more fulsome affidavit. What happens in practice, as most solicitors know, is a short letter is sent to a doctor, and a doctor, either with a pro forma affidavit or something simple for the doctor to sign, the doctor signs it and sends it back. And as Simon said, that usually doesn't cut the mustard, because it's conclusionary and it doesn't go to the substance of why the doctor considers the person had capacity. But just wanted to mention this for practitioners. The LIV released this capacity guidelines and toolkit late last year. This is the concise version, but it covers not only testamentary capacity but also capacity to appoint an attorney, capacity to conduct civil proceedings, defend criminal charges. This is off the script. But it occurred to me that this is a really good resource for practitioners, and it goes through the things that solicitors should do when faced with clients either making a will or otherwise, but for this context making a will or a power of attorney where their capacity is questionable. And one of the things it draws out is where you do need to get medical evidence. The Elder Law Committee of the LIV has also produced a sort of a pro forma letter that's quite detailed in the instructions that one should give to the doctors about tests for capacity and fleshing that out. So what you find is that if the sort of instructing letter to the doctor is more fulsome, you'll get back a more fulsome response or affidavit from the doctor. So rather than just the simple affidavits we sometimes see, yes, Mr. Bloggs had capacity, it would be a properly worked out affidavit. So that's all available online, as I understand it, and available for your review when you have time.
Thank you, Justin. Just to go back to the signatures of the two witnesses in the informal document in Rhys Sanders, I presume they wouldn't have been in the same ink, and that was an apparent problem on the face of the document?
I think when I first saw it as well, I said, how do we know they weren't signed at the same time? Because I don't think they were. It was apparent on its face, but I think it came out early in the evidence that she had gone, I think, to the newsagent, had her will witnessed, and then went across the road to the jeweller shortly thereafter. The newsagent was a better witness, and she recalled it quite well, and the jeweller was just completely vague and had no recollection, except he realised it was his signature and recalled doing it. So. Yes.
I just wanted to also remind you of that little quirk, if I could express it in that way, in Section 7, the formalities relating to the execution of a will. So the signature is required to be made or acknowledged by the testator in the presence of two or more witnesses who are present at the same time. So that's obviously something that sticks in our minds. It's plain vanilla. But then it goes to the next subparagraph, 7.1d, and at least two of the witnesses, because there might be more than two, but at least two of the witnesses must attest and sign the will in the presence of the testator, but not necessarily in the presence of each other. So it's that little rider that sort of creates a little bit of uncertainty about what exactly are the requirements. Have I got it right or wrong after all these many years in practice? Okay, so just go to C. The signature's got to be made or acknowledged by the testator in the presence of two or more witnesses present at the same time, which obviously didn't happen in the scenario there in Rhys Sanders. And at least two of the witnesses have got to attest in the presence of a testator, but not necessarily in the presence of each other. The normal situation, in the way in which solicitors would do it in the normal course of their practice, we don't have those problems, but it can just sort of create problems in the sorts of scenarios like we see in Rhys Sanders. Time is pressing on. If I could just move now to the kernel of much of the disputation and the degree of difficulty in these informal will cases. On a number of occasions in the paper before Simon got to discussing the 8 cases, he drew a very important principle to our attention, and I think it's neatly summarised in the first sentence in paragraph 25, because in looking at what section 9 is all about, after you've got over the hurdle of have you got a document, at paragraph 25 of the paper, Simon said, it's important to draw a distinction between the intention to make a will and the intention for a particular document to have testamentary effect. So it's important, just expressing it slightly differently, not to fall too much in love with the fact that you've got a piece of paper in front of you that's talking about the disposition of the deceased estate, wishes in relation to the disposition of the estate on death. That's not of itself going to satisfy the test. The test has that particular document going to satisfy the test that it is going to be one which has testamentary effect. That's the stinger in the tail, and that's where you will often fall and not have a successful application. So, the same very short, succinct statement is made either earlier, I think it's earlier, or it might be later in the discussion of the cases, but I thought it was particularly worthwhile emphasising. And in relation to that, we can then return to the Brigginshaw standard that Simon spoke about earlier on. And you'll see that Her Honour's judgments are, not only in this area but in other areas of succession law, liberally sprinkled with the reference to the need to satisfy her according to the Brigginshaw standard. Now, you'll also be familiar with the fact that Section 140 of our Evidence Act has got a quite short, succinct statement about what's required to satisfy the burden of proof in civil proceedings. Learned commentary about these two things, the Brigginshaw standard and Section 140 of the Evidence Act, sometimes doesn't cause them to be completely lined up. That doesn't stop our judges and doesn't stop our practitioners from perhaps focusing more extensively on the Brigginshaw standard as it's described, and in particular paragraphs from the judgment of Sir Owen Dixon are frequently referred to. But I pose the question, is the Brigginshaw standard different to the balance of probabilities? Either of you to keep that ball started off?
I'll say no, and then you can go.
It's no. So you say no, and I explain why. The answer is no. There's two. It's commonly accepted, I think, and well borne out by authorities that there's two standards of proof. One is beyond reasonable doubt, and the other is balance of probabilities. And from the learning on Brigginshaw and subsequent cases, we know that the Brigginshaw requirement, if I can call it that, doesn't change the standard of proof from balance of probabilities. But what it does is it provides a super added burden on the balance of probabilities, having regard to the seriousness of the subject matter that is before the court. So where you've got allegations of fraud, where you've got situations like in succession law where a person has passed away and they're not there to give evidence, that invokes in the court, it excites the senses of the court, and it puts them on a sort of a train of inquiry whereby they need to be satisfied of certain matters, still on the balance of probabilities, but to a higher level, having regard to the seriousness of the findings or the seriousness of the subject matter. So what we find in the cases is and indeed what we have to apply as practitioners, is the notion that the court will not make a finding on the balance of probabilities with the Brigginshaw standard superadded with inexact proofs, indirect testimony, and so on. You need to get your ducks in a row. That's the short point. You need to gather the evidence. It needs to be admissible. It needs to be cogent. It needs to be consistent, so that the court, when it's analysing this evidence with great care, can have satisfaction, still on the balance of probabilities, but to that higher level, having regard to the seriousness of the subject matter. And I think that's it was Neat and Karajan Holdings, I think, the satisfaction, reasonable satisfaction of the court should not be attained by inexact proofs, indefinite testimony, or indirect references. And in some of the informal will cases, indeed in quite a few cases that you see in the area of succession law, the evidence as it's presented to the court is a bit loose. It's not exact and precise and consistent and sufficient to give the court reasonable satisfaction of the matters before it. It's the undoing of a number of cases in this area. That might be simply because the evidence that you need to satisfy the court to that level is not able to be obtained. That might be the simple answer. After having made all of the inquiries, after having chased every rabbit down a burrow, you just simply can't find the answers to the questions which the court will be interested in. But again, such is the nature of a practice area where the main player, the deceased, is no longer around to give evidence. We have to reconstruct things. We have to make inquiries of neighbours, friends, newsagents, chemists, relatives, etc., in order to put the pieces of the puzzle into place and present that picture to the court so that the court can attain the reasonable satisfaction that it needs to attain before it makes a finding. So no, coming back to the question, it's not a third standard of proof. It still is balance of probabilities, but with a superadded requirement to be pretty careful in the way you put your evidence together.
Thank you, Simon. We are, as I said, very used to seeing references to the Brigginshaw standard in the judgments, and of course it really behoves us all to, especially as barristers, to have actually looked at Brigginshaw. It's a 1938 judgment in the High Court, so it's got a fair bit of antiquity, but for succession law that's probably fairly recent in origin. But it wasn't a succession law case. For those of you who either have read it or would care to spend 15 minutes reading it because it's a tour de force into some legal history, you'll see that it came about because of the application before the court to have a marriage dissolved on the basis of adultery under the old Matrimonial Causes Act. Of course, there was a requirement of proof of fault, and that was one of the grounds. So it's a delightful read in terms of private inquiry agents and attempts to coerce, quote unquote, statements of activities performed and refusals to admit. And if I could put it in this way, to show you how it came about that the High Court had to deal with it, and in particular Sir Owen Dixon had to elucidate these sorts of matters. So it came up in an attempt by the part of an applicant to prove adultery on the part of his wife. And it was before Justice Martin in the first instance, and this is a summary from Sir Owen Dixon's judgment. Martin said that all the witnesses gave their evidence well, and he could gather nothing adverse to them from their demeanour, so they were all okay on credit. He concluded his reasons for judgment thus: I did not know what to believe. I have been very much troubled. I think that, and he then identified a witness called Lamprell, who wasn't called, holds the key. It seems he may have held the pistol at both parties' heads, my reference to coercion. I have done my best to decide, but the petitioner must satisfy me that his story is true. I should say that if this was a civil case, I might well consider that the probabilities were in favour of the petitioner. There's the civil standard. But he finished this part of his judgment by saying, but I am certainly not satisfied beyond reasonable doubt that the evidence called by the petitioner should be accepted. So what he's done in a matrimonial case under the Matrimonial Causes Act is to, at face value, apply the criminal standard. You can see how the matter ultimately got before the High Court. It was certainly easier to get to the High Court in those days. But Sir Owen Dixon finished his summary of the evidence by saying this: my own interpretation of what Justice Martin had said is not only that the evidence had fallen short of satisfying his mind beyond reasonable doubt of the adultery alleged, that's the criminal standard, but that he had not formed an actual belief that adultery had taken place. And when you see some of the commentary in Odgers and the like, you'll see references to, is it necessary for satisfaction of the balance of probabilities that the judge forms an actual belief? And that's referred to in Sir Owen Dixon's summary. He was not satisfied that he'd formed, speaking of Justice Martin, an actual belief that the adultery took place, although he thought that possibly he might consider the probabilities disclosed by the evidence were greater in favour of that conclusion than against it. Okay, so that's going back to first principles, and that is the background that gives rise to the famous couple of paragraphs in Sir Owen Dixon's judgment on which we heavily rely. Thank you. Have you got any questions before we finish what's been, from my point of view anyway, an interesting discussion of this particular area? No? I thank you very much for your attendance. I think time being what it is, we need to wrap it up. I'd really like you to thank the panellists in the traditional manner for a very enlightening contribution.